if I need to say it again.
Yeah, I understand.
Okay. But now, I need a telephone, well, I need a contact that my assistant needs to have, because obviously you may be someplace else. Who's going to be the contact? Is the cameraman going to be the contact person or you? Because we're only going to make one call out of a courtesy. Just write it down on a piece of paper. I don't need it right now, but I will need it. The jurors may focus on the law that they will have to apply to this particular case, but feel free to come and go as you please. This portion will probably take, just to let you know, probably anywhere between 20 to 25 minutes before they actually start the deliberation. So I just let you know that this is going to be taking place at this point in time. All right. Deputy Garrett, if you would bring in the jury, please. Oh, sure. Come on up, Lori. Always, Lori. Always come up, Lori. Excuse me. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in any seat. Just come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Lawyers and parties, you may be seated. If they need pads, pencils, please provide that to them if they need them. We've got plenty of pads. If anybody need a pad, pencil, definitely. Garrett will give you whatever you need. Pad, pencils. Anybody else need a pad? Okay, there's another hand, Deputy Garrett. We need multiple pads. Would you grab some? Anybody else need a pad? Provide you whatever writing instrument you need. You have any more pads, Deputy Garrett, or you're out? I have some. You got more? Everybody, I said pads, everybody needs a pencil. That's fine, he's coming. Anybody else need a pad or a pencil? I mean, we'll provide whatever you need. Okay. Thank you, Deputy Garrett. Ladies and gentlemen, I will provide you the law at this point in time that applies to this particular case. You're more than welcome to take notes if you wish. But I will actually provide you with a copy, but you're more than welcome to take notes. Write down what you want to write down. Don't write down what you don't want to write down. It's completely up to you. Ladies and gentlemen, the grand jury has indicted Andrea Sneiderman with the offenses of hindering the apprehension of a criminal, concealment of material facts, perjury, and false statement. The defendant has entered a plea of not guilty to the indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. You will have out with you the indictment, and I will read that to you, although you're going to have it out with you. Also, you're going to have out with you a proposed verdict form in which you will have to make a decision to each and every count in the indictment. To all of these counts, Mrs. Sneiderman has entered a plea of not guilty, and she is presumed innocent unless and until proven guilty in a court of law. This is case number 13-CR-2413, the State versus Andrea Sneiderman. It was returned by the March term 2013 grand jury. Count 1 charges and accuses Andrea Sneiderman with the offense of hindering the apprehension of a criminal in violation of Official Code of Georgia 16-1050 for the said accused person in the County of DeKalb, State of Georgia, between the dates of November the 18th, 2010 and January the 5th, 2011, did knowingly and willfully conceal facts and destroy evidence of Hemi Newman's guilt in the murder of Russell Sneiderman, which she knew was evidence of the crime of murder. To wit, the accused destroyed text messages and a record of telephone calls between herself and Hemi Newman exchanged on the date of the murder, concealed her romantic relationship with Hemi Newman from police, and concealed her knowledge of Hemi Newman's culpability in the murder of Russell Sneiderman. Count 2 charges and accuses Andrea Sneiderman with the offense of concealment of facts and matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-1020 for the said accused person in the County of DeKalb, State of Georgia, on or about the 24th day of November 2010, did knowingly and willfully conceal from representatives of the Dunwoody Police Department the existence of a romantic relationship between herself and Hemi Newman while that department was conducting an official investigation into the murder of Russell Sneiderman. Count 3 charges and accuses Andrea Sneiderman with the offense of making a false statement in matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-1020 for the said accused person in the County of DeKalb, State of Georgia, on or about the 5th day of January 2011, did knowingly and willfully make a false statement in a matter within the jurisdiction of the Dunwoody Police Department. To wit, accused told Lieutenant D. Barnes and Deputy Chief D. Size that she never suspected that Hemi Newman was involved in the murder of Russell Sneiderman prior to December 28, 2010. Count 4 charges and accuses Andrea Sneiderman with offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the County of DeKalb, State of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Hemi Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that she did not have knowledge that Russell Sneiderman had been shot at the time she spoke to Donald Sneiderman prior to her arrival at Dunwoody Prep, such statement being material to the issue surrounding the murder of Russell Sneiderman. Count 5 charges and accuses Andrea Sneiderman with the offense of making a false statement in matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-1020 for the said accused person in the County of DeKalb, State of Georgia, on or about the 5th day of January 2011, did knowingly and willfully make a false statement in a matter within the jurisdiction of the Dunwoody Police Department. To wit, accused told Lieutenant D. Barnes and Deputy Chief D. Size that she did not know what had happened to Russell Sneiderman at the time she had arrived at Dunwoody Prep, when in fact she knew that Russell Sneiderman had been shot prior to her arrival at Dunwoody Prep. Count 6 charges and accuses Andrea Sneiderman with the offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the County of DeKalb, State of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Hemi Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that she was not romantically involved with Hemi Newman, such statement being material to the issue surrounding murder of Russell Sneiderman. Count 7 charges and accuses Andrea Sneiderman with the offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the County of DeKalb, State of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Hemi Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that none of Hemi Newman's feelings for her were ever returned, such statement being material to the issue surrounding the murder of Russell Sneiderman. Count 8 charges and accuses Andrea Sneiderman with the offense of false statements and matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-1020 for the said accused person in the County of DeKalb, State of Georgia, on or about the 19th day of November 2010, did knowingly and willfully make a false statement during an official investigation into the murder of Russell Sneiderman, to wit, that she told Detective A. Thompson that she had made it clear to Hemi Newman that she did not want him to pursue her romantically. Count 9 charges and accuses Andrea Sneiderman with the offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the County of DeKalb, State of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Hemi Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that she did not share a hotel room with Hemi Newman in Longmont, Colorado, such statement being material to the issue surrounding the murder of Russell Sneiderman. Count 10 charges and accuses Andrea Sneiderman with the offense of false statements and matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-1020 for the said accused person in the county of DeKalb, state of Georgia, on or about the 5th day of January 2011, did knowingly and willfully make a false statement to Lieutenant D. Barnes and Deputy Chief D. Sides, to wit, she denied that Henry Newman was in Longmont, Colorado in July 2010 with accused. Count 11 charges Andrea Sneiderman with defense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the county of DeKalb, state of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Henry Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that at the time she was in Longmont, Colorado with Henry Newman, she believed he was there on business for General Electric, such statement being material to the issue surrounding the murder of Mr. Sneiderman. Count 12 charges and accuses Andrea Sneiderman with the offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the county of DeKalb, state of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Henry Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, that she and Henry Newman did not kiss while in Greenville, South Carolina, such statement being material to the issue surrounding the murder of Russell Sneiderman. Count 13 charges and accuses Andrea Sneiderman with the offense of perjury in violation of Official Code of Georgia 16-1070 for the said accused person in the county of DeKalb, state of Georgia, on or about the 21st day of February 2012, having been given a lawful oath in a judicial proceeding, State versus Henry Newman, 11 CR 1364, did make a false statement in a judicial proceeding material to a point in question, to wit, the accused testified that it was due to her mother's, Bonnie Greenberg's, concern for the accused's safety that she did not immediately report her suspicions of Henry Newman's involvement in the murder of Russell Sneiderman to the Dunwoody Police Department, such statement being material to the issue surrounding the murder of Russell Sneiderman, contrary to the laws of said state, good order, peace, dignity thereof, signed Robert B. James, District Attorney. To all of these charges, Andrea Sneiderman has entered a plea of not guilty, and she is presumed innocent unless until proven guilty in a court of law. As I indicated earlier, you will also have out with you a proposed verdict form in which it will be reduced to writing whatever your verdict is. Where conjunctive pleading set forth more than one act by which the accused committed the crime, the evidence is sufficient so long as it shows at least one of the acts alleged. If a crime may be committed in more than one way, it is sufficient for the state to show that it was committed in any one of the separate ways listed in the indictment, even if the indictment uses conjunctive rather than the disjunctive form. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, that the crime was committed in DeKalb County is a judicial fact that must be proven by the state beyond a reasonable doubt, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it will be your duty to acquit the defendant. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or the acts and conduct, or it may, in your discretion, inferred when it is the natural and necessary consequences of the act. Whether or not you draw such an inference is a matter solely within your discretion. Intent can be general or specific. General criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. Certain charges require specific intent, and I will instruct you specifically about those charges. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of the words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to have sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and proper consequences of those acts. Whether or not you make any such inference is a matter solely within the discretion of the jury. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely rise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses, any exhibits submitted during the trial, and stipulations of the attorneys. That is, any facts to which the attorneys have agreed with approval of the court. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into a stipulation that have been approved by the court about certain facts, testimony, documents, and exhibits. Where parties stipulate facts, this is in the nature of evidence. You will take that fact or those facts as given without the necessity of further proof. However, you are not required to do so. You make all decisions based upon the evidence in this case. Where parties stipulate testimony, documents, and exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it as if you find it to be credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is a testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond reasonable doubt. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence to prove facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence made on any given issue is a question of fact for the jury to decide. You may consider evidence of habit of the defendant if shown, insofar as it may show, if it does, that the conduct of such person at the time in question may have been in keeping with such habit. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given by certain witnesses whom are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. The defendant does not have to present any evidence or testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. The credibility of a witness may be attacked by disproving the facts to which the witness testified. In determining the credibility of any witness whose credibility has been attacked, as I have described above, in any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. This would include lack of bias toward a party, truthful conduct, extrinsic evidence or cross-examination, specific instances of conduct of the witness only after the witness has been attacked, and that may relate to the witness's lack of bias toward a party. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to attack the credibility or believability of any such witness. This would include evidence of bias toward a party shown by bad acts, extrinsic evidence, or cross-examination, specific instances of conduct of the witness in question that may relate to the witness in question's bias toward a party. You may determine whether there was evidence that a witness testified falsely about an important fact during the course of the trial as opposed to some other time before this trial. In so doing, you may make a determination whether the misstatement was because of an innocent lapse in memory or an intentional attempt to deceive. You should consider all of the facts and circumstances of any prior statements. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness provided you find the evidence to be sufficient. An exception to this rule is made for the offense of perjury. The testimony must be supported by other evidence of some type that supports a finding that the offense was committed. It is not required that supporting evidence be sufficient to warrant a conviction or that the testimony be supported in every material particular. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you, beyond a reasonable doubt, that the accused is guilty. A person to whom a lawful oath or affirmation has been administered commits perjury when, in a judicial proceeding, that person knowingly and willfully makes a false statement material to the issue or point in question. The testimony of a single witness is generally sufficient to establish a fact. However, in certain cases, including prosecutions for perjury, the testimony of a single witness is not sufficient. There must be corroboration. Nevertheless, corroborating circumstances may dispense with the necessity for the testimony of a second witness. Perjury is the willful assertion as a matter of fact, opinion, belief, or knowledge made by a witness in a judicial proceeding as part of the witness's evidence and given in open court. Such assertion being known to such witness to be false and being intended by the witness to mislead the court, jury, or person holding proceeding. The question of whether particular statements were material depends upon the nature of the proceeding and the matters at issue, and can be determined in each case that case only. One test of materiality being whether the alleged false statements could have influenced the decision as to the question at issue. When a party or witness testifies on a material issue, either as part of the case in chief or in a defense, the credibility of the witness becomes relevant. And so matters relevant to the witness's credibility and collaterally material to the issue about which witness is testifying, or material for purposes of perjury. Perjury may be assigned on false testimony going to the credit of a witness. If a witness testifies to a material issue at trial, then false testimony going to the credibility of that witness likewise can be considered material. Whether the false statement was material is normally an issue for the jury. A person commits the offense of hindering the apprehension or punishment of a criminal when, with intention to hinder the apprehension or punishment of a person whom he knows or has reasonable grounds to believe has committed a felony, he conceals or destroys evidence of the crime. A person who knowingly and willfully makes a false, fictitious, or fraudulent statement or representation in any matter within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of the state shall be guilty of the offense of false statements. As to the charge of false statements, the state must prove beyond a reasonable doubt that the defendant knew that the statement was false. A person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact in which any matter within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of this state shall be guilty of the offense of concealment of facts. The state must prove beyond a reasonable doubt that the defendant had the intention to conceal a material fact from the government. Silence or non-disclosure is not an affirmative act. By no ruling or comment from the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. One of your first duties in the jury room will be to select one of your number to act as foreperson who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You must start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, between the dates of November 18, 2010 and January 5, 2011, commit the offense of hindering the apprehension of a criminal as alleged in count 1 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we the jury find the defendant guilty. If you do not believe that the defendant is guilty of hindering the apprehension of a criminal, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event the form of your verdict will be, we the jury find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did on or about November 24, 2010, commit the offense of concealment of material facts as alleged in count 2 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we the jury find the defendant guilty. If you do not believe that the defendant is guilty of concealment of material facts, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event the form of your verdict will be, we the jury find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did on or about January 5, 2011 commit the offense of false statement as alleged in count 3 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we the jury find the defendant guilty. If you do not believe that the defendant is guilty of false statements, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we the jury find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about February 21, 2012, commit the offense of perjury as alleged in count 4 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we the jury find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict will be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about January the 5th, 2011, commit the offense of false statement as alleged in count 5 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of false statement, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event the form of your verdict will be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia, on or about February 21st, 2012, committed the offense of perjury as alleged in count 6 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about February 21st, 2012, commit the offense of perjury as alleged in count 7 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about November the 19th, 2010, commit the offense of false statement as alleged in count 8 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of false statement, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt as to that the defendant in DeKalb County, Georgia did, on or about February 21st, 2012, commit the offense of perjury as alleged in count 9 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about January the 5th, 2011, commit the offense of false statement as alleged in count 10 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of false statement, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about February 21st, 2012, commit the offense of perjury as alleged in count 11 of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about February 21st, 2012, commit the offense of perjury as alleged in count 12 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia did, on or about February 21st, 2012, commit the offense of perjury as alleged in count 13 of the indictment, you will be authorized to find the defendant guilty. In which event, the form of your verdict will be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of perjury, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant. In which event, the form of your verdict will be, we, the jury, find the defendant not guilty. Whatever your verdict is, it must be unanimous. The verdict must be in writing and signed by one of your members as a foreperson, dated and returned and published here in open court. In a few moments, you will retire to the jury room. However, do not begin your deliberations until you receive the indictment and any evidence that has been omitted during the course of the trial. However, while you are waiting for the evidence to come in, you may go ahead and select a foreperson. The foreperson will serve as a spokesperson for you as a whole. At this point, Deputy Garrett will escort you into the jury room. Jurors number, if you remember your numbers, 61, 66, and 72, just remain with Deputy Garrett in my hallway. I'm going to have some special instructions for you momentarily. And if you do not remember your numbers, I will give you your initials. Jurors number 61, 66, and 72, remain with Deputy Garrett momentarily in the hallway. I have some special instructions for you. If you do not remember your numbers, I will give you your initials. 61, 66, and 72, remain with Deputy Garrett in the hallway momentarily. I have some special instructions for you. All right, lawyers and parties may be seated. Any objection from the state?
No, sir.
Who's Mr. Petrie?
Your Honor, we would renew our objections, and the court, of course, considered all of our requests, a number of which the court did not agree to give. I know previously we could reserve the right to bring up this objection later. We object at this time to the exclusion of all of those charges. And Your Honor, at this time, I'm going to ask the court to consider on the statutory definition of hindering the apprehension that was given to the court. It is a correct statement of the law, but it includes a phrase that didn't click with me earlier. I think we had something like 70 requests to charge between us and the state. On the hindering apprehension, Your Honor, this particular, which is now count 1.
Correct.
The state does not allege that Mrs. Sneiderman knew or should have known. It specifically alleges that she knew.
Okay.
And the statutory definition includes language that the defendant knew or should have, or has reasonable grounds to believe has committed.
Yes, sir.
I'm afraid that the statutory definition could be misleading to this jury and could allow them to say, well, even if she didn't know, if she had reasonable grounds to know, then we're authorized to convict. That would be true had the state alleged this as, you know, in the conjunctive, they left it out of the indictment. Honestly, this is something I wish I'd caught earlier because it is an error in the charge that I didn't catch earlier. I do believe it should be corrected for the jury. That is the only objection in the statutory definitions that we have.
All right. Do we hear from the state?
I don't agree with Mr. Petrie's argument that would permit the jury to convict in a way that they wouldn't be authorized to. However, I also don't object to a recharge omitting the language that Mr. Petrie now objects to, that he didn't object to last night.
I recognize I did not, and I take her up on her offer if the court's so inclined. And I think that most of these cases deal with theft, where it talks about you can commit a certain type of theft of shoplifting by doing any of the following acts. If the statute, if the indictment alleges a specific way that you did it, that's what the state has to prove. So here they allege in the indictment that she knew, not that she had reasonable grounds to know, or that she might have known, or that she could have known, but they allege that she knew. So that is what we believe this jury must find before they'd be authorized to consider a conviction in that count.
All right. Mr. Petrie, as I think I heard you say, when we went through this last night, it was not brought to the court's attention, and you had consented to number 20, where you had no objection to 25.
That's correct, Your Honor.
I understand. And, well, and I'm hearing Ms. Cross saying, so Mr. Petrie, assuming without deciding, I will go along, if the state is not objecting, with your recharge, you wanted to read a person commits the offense of hindering the apprehension of a criminal, hindering the apprehension or punishment of a criminal when with intention to hinder the apprehension or punishment of a person whom he knows
Has committed a felony.
And delete, he knows, and delete the language.
Or has reasonable grounds to believe, Your Honor. And
right, that's what I don't make sure we're on the same page. You want me to delete after O?
Yes, sir.
Whom he knows has committed.
That is correct, Your Honor. And you're exactly right. I did not object to this earlier because it's a direct recitation of the statute, but the peculiarities of this count weren't clicking with me.
Not a problem, Counselor. what I'm going to do, lawyers, yeah, I have a problem. The state has no objection to it, although there was no objection, but I have no problem bringing it back out, and we'll make that change, Ms. Jeffries. Not a problem.
Thank you, sir.
Anything else?
No, sir.
All right,
I
that
appreciate it.
request, you're quite welcome. Deputy Garrett, we're going to do two things. I need to bring all 15 of them out before I give, let me do this first. Lawyers, my normal procedure, what I'm going to do after I give this quote-unquote additional charge is to, I normally put the alternates on call. I don't just keep them in the building indefinitely. That's the procedure I always follow. Is there an objection from the state, from the court following its normal procedure?
No, sir.
From the defense? Who's talking to me?
No, sir, there is no objection as long as they are instructed not to watch any news
Oh, yeah,
broadcasts or have any contact or discuss the case with anyone.
Yes, sir. Yes, sir. Yes, sir. I will follow your recommendation. I will give that instruction. So I normally do, but I will give it since you have brought it to my attention to give it.
Yes, sir, thank you.
All right. All 15. Please. Come on in, ladies and gentlemen. Come on in, ladies and gentlemen. Make yourself comfortable. Come on in, ladies and gentlemen. Make yourself comfortable. You can sit in any seat. You don't have to sit in any assigned seat. Just come on in, ladies and gentlemen. Come on in, ladies and gentlemen. Just make yourself comfortable. Just sit in any seat. Just sit in any seat for right now. Come on in, ladies and gentlemen. Come on in, ladies and gentlemen. Make yourself comfortable. Just sit in any seat. Come on in, ladies and gentlemen. Just make yourself comfortable. Everyone should have a seat. I know the seating sequence is a little bit off, but that's wonderful. Boys and parties, you may be seated. Ladies and gentlemen, I am going to reread one portion of the charge, but take this in combination with everything that you've heard up to this point. And a person commits the offense of hindering the apprehension or punishment of a criminal when, with intention to hinder the apprehension or punishment of a person whom he knows has committed a felony, he conceals or destroys evidence of the crime. All right? You may follow my instructions. If you could hold those jurors in the hallway, I have some special instructions. But don't start your deliberations until you get the information from Deputy Garrett. And I'm still jurors number 61, 66, and 72. I'm going to have some special instructions. You may go into the jury room and go ahead and select a fourth person while you're waiting. Lawyers and parties may be seated. Any other thing from the state?
No, Your Honor, I thank you.
I'm sorry, from the state first.
He got confused, Judge. No, sir.
Okay. Anything else from the defense?
No, sir. Thank you very much.
Thank you. Bring in my three, please. All right, ladies, make sure. And you should be, we don't have to raise your hands right now, but you should be 61, 66, and 72. And let me just confirm and make sure. '61 initial should be GAH, 66 should be PS, and 72 should be KH. Do those numbers, do those initials match up with the numbers you believe them to be?
Yes.
All right. I do know your names, but I just for various reasons, I'm not disclosing that right now. Juror, you are actually, for right now, the alternates. And the 12 individuals who are in the jury room, they make up the body right now. You would not be actually involved in the deliberation unless one or more of them become incapacitated and they cannot serve in the jury and continue to deliberate. What I normally do, we're going to collect up your pads, and Deputy Garrett is going to give you an envelope so you can put your notepads in, and nobody's going to look at those notepads. They're going to be sealed. And if you're needed, you're going to be called, you're going to be requested to come back, and then you will come and you'll be put in, and I will give additional instructions, and the jury will deliberate at that point with any of you if you have to be substituted, okay? Now, when I say please put on call, now, do not, let me distract you, do not go to work tomorrow, okay? And when I release you, I'm going to give you some other instructions. It's going to be the same thing you heard before, but when I release you, do not discuss the case. I'll allow anyone to discuss the case with you. Let me go ahead and give you those complete instructions right now, and I'm going to give you some special instructions. When I do release you, you're going to exit through your private exit. Do not, because I don't want you to hear anything you should not hear, anyone you should not interact with. Do not read any media coverage about this case. Do not go on the internet about this case. Do any research. Do not blog about this case while it's ongoing. If you are called back, you're going to have to base your decision upon the evidence that you heard and what you're reviewing, plus the law that I have provided you. But you're not doing anything independent. Do not go to any location that may have been made reference to during the course of the trial. The evidence portion is closed. If you are called to come back in, I will give you, I won't be calling, but someone will be calling to give you specific instructions on to come back, and you will start that process. Still, the lawyers and parties cannot talk or interact with you just like you've been doing for the last couple of weeks. I will not give you a report back time per se, other than I'm going to put you on call for the rest of the day and also tomorrow, okay? If we have to contact you, because on that envelope you're going to write down your name with a telephone number. Now that's not going to be revealed to anybody but people on my staff. Also on that envelope, on the inside flap, I want you to write down your favorite color. And the reason is this is going to be your code. Because see, I can't control what people actually do with you. See, only you're going to write it down, the only person who has the envelope is going to be able to call you, and they're going to be able to say, and you're going to be able to say, what is the color I wrote on the envelope? If they don't give you that color, do not talk to them, because somebody's trying to trick you to do something you should not do, okay? So that's why that's going to be written there, okay? Also, if in doubt, you're going to be able to call my office and say, did you just call me? Because the number, the person who's going to be calling you is going to be calling from this office. But the number that's going to be on your caller ID is not that number, because we have a system in which that number is not going to appear. So that's why you may want to have to call my office. You understand what I'm saying? That's about the best I can do. Now, at this point in time, I have not identified you by name. You're not known at this point in time. I'm doing everything I can to protect your identity. Now, there will come a time, not yet, in which you will be actually released. The person who's going to be calling on my behalf will give you, they're going to call you anyway. One or two things: to come back and be involved, or B, to tell you thank you, your service is no longer needed. That's what I'm saying. But for right now, you're still, in this case, you're still on the jury for right now. Tomorrow, you're still going to be on the jury. I understand, unfortunately, it's being televised, your employees know, but you cannot go to work tomorrow if you go to work. That's all I'm saying, because I need you available. If you go out, and you can leave your home, but you need to make sure you can be back on my site if I need you within 1 hour. I'm giving you some flexibility. You know, if you're working in your yard, I'm just using an example, have your cell phone with you so that if it's vibrating or buzzing, you can answer the phone, because when we call, we're going to need you. Okay, you understand what I'm saying? And that's all I'm going to do for right now, give you those instructions. Any questions about logistics? Wonderful. No questions by you. Just make sure you put your notes in there. And also, Deputy Garrett is going to take your badge for right now. He has a letter that has been prepared at my request indicating that you've been here since Friday, filling out the question all that time. So if you need that for your employer, if and when you go back, and that may say through the day, if it needs to go through tomorrow, that'll be fine. I can get that changed and updated, okay? But you understand, don't talk to anybody on the phone unless they give you that code that you're going to write down. And write it so that no one can see what you're writing. Okay, well, actually, I'm going to let you write on the back hallway, because I don't want anybody to try to figure out what it is. Okay, I don't think it's going to happen, but I'd rather err on the side of taking this extra step. You're still on the jury. I could, to make it convenient for you, I'm not going to let you just sit in a separate room somewhere, because I just have to, you understand what I'm saying? Because you're not sequestered. All right, any questions about logistics? Wonderful. Hearing none, if you could follow instructions of Deputy Garrett, he's going to talk to you in the back, and you're going to be able to leave at this point in time. Have a wonderful evening. Talk to you soon. Thank you for your service. Okay? Don't forget to write down that code, please. Lawyers and parties may be seated. Lawyers, if you would approach Kelly, you may have done this already, if there's an agreement on what should go out to the jury, those items, as we normally do, if you could put them on this is my term, the far banister on what you agree to. If there's a disagreement, I will come back in and resolve those issues. I'm just going to step away for a moment. You can contact Kelly, and I will come back and resolve those issues before those items go out. How much time do you need, Laura? I know it's a lot of items, but you've been keeping a list.
I think 10 minutes Should be it.
Okay, is that 10 real minutes?
Yes, sir.
All right, what you got, I'm gonna give you 10 minutes, and it'll be, Mr. Deputy, it's gonna be 10 minutes, real minutes? All right. 1 second. The jury's already.
Okay. Welcome back, everyone, to 11 Alive's continuing coverage of the trial of Andrea Sneiderman. I'm Jeff Hellinger, along with Zara Karenchak, and she has been with us from the beginning this morning. We are very appreciative for your expertise, your analysis. You went to Emory Law School, did your undergrad at the Air Force Academy, served with Governor Barnes. You've been a former federal prosecutor. You're now a defense attorney. You have been around the block on these kinds of issues. Would you explain to us what we are in the midst of watching right now?
So at this point, the judge has charged the jury with the applicable law for the case, and they're taking a break, and the parties, the prosecution and the defense, are now going through the items of evidence to talk about whether they agree on what can go back to the jury. And if they have a disagreement about some piece of evidence that they don't want to go back to the jury for some reason, then the judge is going to come back in and rule on that.
We're taking a look at Andrea Sneiderman right now, and her mother, Bonnie Greenberg, is there as we are looking carefully, surrounded by a group of loyal friends who have been with her in the courtroom today and through other days as well in this DeKalb County courtroom. She took a pounding from District Attorney Robert James during the closing argument, calling her a liar. He would walk over, get in her face. Her eyes were cast downward. But that is a very tough thing to have to listen to in a courtroom.
That was a very tough closing to sit through.